Welcome, everyone, to this general government meeting of June 8th, 2022. No, can we have a roll call, please? Julie?
Sure. Good evening, everyone.
Good evening.
Councilmember Dennehy,
Here.
Councilmember Worthington,
Here.
Councilmember Schmischer,
Here.
Councilmember B. Smith, Councilmember Stein,
Here.
Councilmember Tracy, I think
She is on Zoom.
She's muted, but she is on Zoom.
Mayor Pro Tem Hamrick,
Here.
Mayor Smith.
Here.
This evening, we're having two discussions, actually three. We're talking about chronic nuisances, our city charter, and also a path forward after our last Thursday's meeting, workshop, public input about homeless. And so what does our revised agenda say as we, chronic nuisance first. So,
I'll take it away.
great, thank you.
Thank you. So as some of you will remember, in March at a general government meeting, we talked about a draft chronic nuisance ordinance. And overall, the purpose of that is to put basically another tool in the toolbox for code enforcement. And it's meant for the most egregious and, I guess, troublesome cases. It's not meant to be used for times in which, you know, there's weeds on the property or something like that. So staff and the city prosecutor is on the phone too, or on Zoom, Tricia McCarthy, in case, you know, you have any questions or she wants to add anything. But we kind of went back and reworked the ordinance a little bit. As I mentioned in the memo to you, we had talked about, you know, multiple notices being issued to one property. And as Tricia and I talked, you know, that's not really how the city operates. We wouldn't keep noticing a property for the same violation. We would push that violation into court if we hadn't achieved some progress on it or compliance. So we've kind of changed that first section of the ordinance, which talks about when a summons and complaint can be issued without notice. And so currently in the draft you have, it's 3 written notices have been issued to a property within any 12-month period. And the owner or occupant is currently subject to a deferred judgment agreement or probation agreement on a previous nuisance, or the municipal court has deemed the property a chronic nuisance within the past 2 years, and the property has been subject to a notice of violation within that 2-year period. So that just triggers when a community services officer can go straight to summons and complaint. The second section of the ordinance has also been rewritten. So in the original section talked about, you know, 3 or more occasions during a 60-day period, and 3 or more notice had been issued during that period, and that the activity constituting a violation has been visually observed or otherwise witnessed, and then that the nature of the activity creates a substantial threat to the health, safety, welfare of the occupants of the property or the neighboring properties. And so we decided to rework that and now have, you know, 5 instances that may be considered a chronic nuisance. And so that's a habitual or continuous violation of the Title 8, and that's the nuisance title. The nature of the activity, that substantial threat, we left that in there. The property owner permits an action or condition to occur or exist that intrudes on the ability of the neighbors or citizens to use or enjoy their properties or public property adjacent to where the nuisance occurs, or fails to perform a duty or action that results in the same. And a failure to comply with lawful orders of the municipal court which pertain to enforcement under Title 8, or the property is abandoned and illegal activity is occurring and documented. So we thought those were a little bit more specific about what we're seeing and what we might want to tackle if we were to use this chronic nuisance. And so as you'll recall, the chronic nuisance, you know, they're still served with the complaint and everything like that. It just shortens the time to abate, and also gets it in front of the court on a faster schedule. So, and I know we talked about this and I related in the memo as well, but you know, we just had a code enforcement meeting, not 4 hours ago. So there's a lot of communication going on with nuisance enforcement in the city. We have these monthly meetings, and Tricia's on the phone. I'm on the phone, community services, building, planning, anybody who might have some type of code enforcement, those departments are there. And, you know, the police department's there as well. Elliot skipped today's meeting, but that's okay, we won't call him out for that, so we're having those monthly meetings, and, you know, Tricia and I are Tricia more than me, but are in pretty much constant communication with code enforcement, trying to help out and assist. We've got some really challenging cases currently, but, you know, trying to answer questions and help everyone. So it's a really lot of information flowing back and forth, so. So I'm happy to answer any questions.
So with that, does council members have any questions? Amy, I see you reaching for a button, is that right?
Oh, I was not, but I do have questions. I
sure.
don't have to go first, though. I think one of my primary questions is, in 842.015 chronic nuisances A1, it then has the list of A through G, and it's an and or list, which I believe means that if any of those conditions exist, then it could be defined as a chronic nuisance. And I'm a little bit concerned about that, because some of those are not necessarily chronic in nature, or they aren't specified within their specific clause in such a way that would make it chronic in nature.
Can I ask you to elaborate just a little bit? Because I'm not sure I'm following exactly. So you're concerned that the factors to be considered in determining whether something's continuous and habitual violation of the section, that these aren't chronic conditions? Do I have that right? I'm sorry. I don't.
No, and let me maybe say it in a slightly different way.
Okay.
So I don't believe that let's see. So A through G is an and or.
Correct.
And then 1 through 5 is also an and or. So really any pairing of an A through G and a 1 through 5 would lead us to define it as a chronic nuisance. And I am a little bit concerned that some of those pairings may not actually rise to the level of chronic nuisance.
Okay. Is there any one sense specifically that you are concerned about? And maybe chronic is technically not we're defining it as something. I think it's not just something that you would consider chronic by the definition of chronic. It's also something like number 2 is, you know, the nature of the nuisance activity on the property results in a substantial threat, health, safety, and welfare of the occupants of the property or the neighboring properties. It doesn't have to follow the dictionary definition of chronic to be a chronic nuisance, because we're defining what that is.
Sure, and I'm not concerned about the dictionary definition of chronic. I'm concerned about how our city enforces its ordinance on citizens.
Well,
so
and
for example, 1C, and there are literally, I think, 25 different permutations, but 1C is number of violations of this title, but we don't define how many violations we mean in 1C. So then if you couple 1C with any of the others, number of violations could be 1 or 2.
And I guess I would say that's part of I think the issue that council's had with nuisance enforcement in the past as well, is that the discretion that's left to the code enforcement officers and staff to make these decisions. And I mean, we can put a number in there. You can say 80, and then we can have someone who has 40 but should be a chronic nuisance. And so staff needs a little bit of flexibility to, you know, to deal with situations and to apply the code. In addition to that, I mean, that's why I mentioned the conversations they have with our office, and so they're seeking guidance and we're talking things through. There is also a code enforcement policy manual that helps them make those decisions. And so we can address those things about, you know, numbers of violations and types, those kinds of issues in that manual to help guide them make the decision. But it's going to be case by case. And so if we put a number in there, my concern is that we'll never be able to use that as an avenue, because it will never make it. So that's why we drafted it the way we did. But-
Sure. I think it's incumbent upon us to make sure that we're not passing ordinances that short circuit the rights of people who live in Canyon City. I understand why we need this kind of ordinance, because we do have chronic nuisance properties, and we want to make sure that our code enforcement officers have the tools that they need to be able to effectively deal with those and not kind of go through the same process over and over and over and have it drag out for so long. But I do think that in some of the other A through G, where it gets really specific, like a property on which activity has been witnessed on 3 or more occasions during any 60-day period, like it makes sense. Okay, this is happening for a prolonged period of time. We've documented it. We've told them that this is a problem. Got it. Let's take more advanced actions. My concern stems from when we are pretty general and pretty vague, a number of violations of this title. Like, so if I let my weeds grow too high, like for a week, and somebody drives by twice, and then you're going to take me to court for that, like that's just.
But that's not what this is for.
I know it's not what it's for, Catherine, but I think it's really important that our ordinances protect people and don't just protect government.
Well, but I think the issue is that the nuisance process itself, from start to finish, has a lot of protections for property owners. So, we have internal discussions, making, calls on, within our discretion as to what path to take. And then, we have to take it to court. We have an independent body sitting in judgment in the case we bring. And if the judge doesn't feel like, if he feels like we're out of line, he's going to tell us. And so there are protections there. I just don't want it to sound like there's none.
Sure, but I wouldn't want a citizen to be taken to court unnecessarily. Like, I think that already creates a pretty fraught relationship. So I just want to make sure that we're crafting something that gives us the tools that we need in order to take care of problems, but isn't overly broad, that is specific.
This ordinance, this is beyond the not taking people to court if it's not necessary, because we already have that in place. Like you said, that's already taken care of. If there's progress being made on a case, if there's, good intention for compliance, you're not going to court. This is for those that are the chronic violations. This is the egregious.
Yeah, and maybe Wendy can talk a little bit about
We also
the
have
initial
Tricia.
notice process.
Tricia also has her hand
she waving.
raised too.
Sorry.
Yeah.
So, Tricia, go ahead, please.
Thank you. Hello, everybody. My name is Tricia McCarthy. I am your prosecutor. I did want to point out these are our chronic nuisance cases. These are not our weed violators. These are not the people that have some junk in their backyard or front yard or have a derelict vehicle. And I don't want to name any properties in particular, but we have had several properties in Canyon recently that we've done several abatements on, where there's been 40 cars on the property. There's been trash piles that have required, I believe the one property required, 10 to 12 roll-offs in order to clear the junk from the property. We had another property where there was a burnt out house that the homeless were living in. And when we looked at that property, that house was in severe danger of collapsing on the people that were living within that house. We had another property that the house almost burned to the ground. Once again, a huge risk of structural issues, as well as all the other nuisance issues that are on the property. So right now we probably have about 12 of those properties on our identified list. Just to explain the process, and Catherine started to explain the process, we do have the code enforcement team that meets on a regular basis. The code enforcement team consists of members of the police department, the code enforcement team, members of city staff, including both Catherine and I. We identify properties that we're concerned about. We talk about them. We talk about the goals. Catherine and I are basically reviewing the majority of the notices of violations that go out on any of these properties that we are concerned about, that have risen to the level of what we would identify as chronic, even though technically we don't have a chronic nuisance ordinance yet. We are giving advice and guidance to the team, as well as the team is also using their discretion. When we move forward, we have to move forward with notices of violation. One of the reasons why we're asking for this chronic nuisance and for you to consider it is we have properties that we're going to notice a violation on multiple times. As we go to notice a violation, we go to court, we get the abatement, and then 2 months later, the property is back into the same condition it was prior to the abatement. This allows us to speed up that process with these properties that have been identified. In addition, we have checks and balances. This isn't just one person making a decision. It is the team. You do have me as the prosecutor that has to review everything on a legal basis to determine whether or not the case is valid, whether we have complied with all the notice of violation requirements, as well as all the other requirements under Title VIII. And then finally, you do have the judge. And the judge is the factual finder. He is the one that determines the facts and determines whether the city has proven the facts that are necessary to support the chronic nuisance. So while we may bring someone into court on a chronic nuisance, the judge ultimately has to determine whether it is a chronic nuisance. To look at 842-15-1C, I can tell you right now, that is not going to be the only reason why we bring someone in under chronic nuisance. The properties that we have identified would probably qualify under all conditions under A. I would say almost probably, and Catherine could probably give me an estimate, I would say at least 75% of the properties on our list right now qualify probably for every single condition.
And I'd like to say, in answering your concerns, the problem that we have is that if we are so specific, that we tie the hands of our code enforcers and our attorney in this matter, because there could be a condition that arises that's outside of the words that we have on the paper. What we have here is so that's one concern. But what we have here on the A through G are examples, factors to be considered, and it does say and or. I agree. But I think that if I was a citizen reading this, I would like to see those factors enumerated so that I had some idea. I understand your concern about that the number of violations, is that 1 or 2, or how many is that? But it's not to be considered in its as a sole determiner. And is that really the source of your problem that you're telling us about?
I think that's an example of the problem.
Mm-hmm.
And I certainly appreciate that it's not certainly our code enforcement officers or our city attorneys' intent to misuse it. But I think it's incumbent upon government to write as specifically as we can so that we're not creating overly broad laws that could be used, ordinances that could be used by people with different intent down the road. I think we do need to be, I'm not saying that we need to have a specific number of violations, but if I understood Prosecutor McCarty and Ms. Sellers correctly, like maybe we don't even need C and D in here, because those are the two that are really pretty broad and are essentially just saying if you have more than, if you have a violation and if you have a significant violation, whereas I feel like E, F, and G are, and I guess to an extent A and B, although I am a little bit concerned about B, they're at least a little bit more specific. And if I understood you correctly, most people meet most of these anyway, or not most people, I'm sorry, most cases meet most of these anyway. So I don't understand why eliminating some of the...
That's not what she said, sorry. I just need to clarify. She's saying the major ones on the list we keep, the 12. 75% of those meet this criteria. Those are not weed cases. Those are the kind of extreme cases that she was talking about.
Sorry, those are not what cases?
Those are not weed cases.
Like you said, you don't want people going to court over weeds.
At our monthly code meeting, we address the most egregious cases. At 12 to 15, the list kind of changes. And what I think Tricia was saying is 75% of those cases, the most egregious ones, meet this, not cases across the board.
Sure, no, I understand.
Okay,
Correct, that's what I meant. And the most egregious, the cases that you probably drive around Canyon and you recognize them. They're cases that any citizen would go by that property and think to myself, wow, that property's dangerous. That property has conditions that people shouldn't be on that property. Those are the cases I'm talking about. I'm not talking about the general cases.
Sure. So I mean, if any citizen could recognize a chronic nuisance, I think it would be incumbent upon us to just be a little bit more specific in how we define it so that we're not writing it in an overly broad fashion.
Wendy, did you have something that you wanted to add to that?
No, I think Catherine and Tricia have both covered it. It just, I mean, this is for our worst case, absolute worst case scenarios. These properties are the ones that get us accused of not doing our jobs because they're such repeat offenders. You can't tell that we were there last week and got the property cleaned up. So, and it's, you know, if we have to go through our nuisance process every single time, it's 2 weeks, it's a month, it's 2 months just to get to the point where we can bring them to court. And this helps cut that down on those chronic repeat offenders, if you will. But yeah, it's like they said, it's not our everyday, you know, 90% of the people we deal with, we say, hey, you need to clean this up, you need to cut your weeds, you need to do this. They're like, oh, I'm sorry, you know, we'll get this taken care of this week, and it's done. But then there's that 10% that are on our list, and the list they're talking about, those addresses rarely come off of the list, and if they do, they come back on in a month or two. So we're talking about the same people over and over and over again. So, but yeah, Trish and Catherine covered it. So.
And to be clear, absolutely want to give you the tools that you need to do your job and to take care of those properties that are continual challenges.
Are your specific current concerns, did you have some alternate language, or are you suggesting that we delete B and C, or did you have something specific you were thinking?
I mean, I think deleting C and D would be a start. I guess.
Did I misspeak? I meant C and D. Is that correct?
I do have some concerns about B, which states any case in which the owner is currently on probation or supervision of the municipal court, because they could be on probation or supervision for any number of reasons that may or may not have to do with code ordinance. So I am a little bit concerned about B, but I think my primary concern about the overly broad potential application comes from C and D.
we can fix B. B is
Just-
not meant to
Just
be.
clarify that.
Yeah,
Yeah.
that's fine.
And
Meant to apply to any code case in which they're currently on supervision.
that would be B. Mhm.
Well, for the number of violations, I feel like that might need some flexibility because it kind of depends. Like if it's a violation where somebody could die, imminently die, or you have, I mean, I don't want to be specific, but there are some really dangerous things that we've had going through our codes lately that is very life-threatening, extremely dangerous. That's an instance where if you violated that one once, the second time, it's so serious that it needs to be taken care of.
Yeah, and we're not gonna look at C for that kind of thing. C is the number of violations. We're gonna look at more like D, the degree in nature, and some of the other factors regarding, you know, how
Okay.
dangerous it is and the safety of the people in the home or on the property and the people next door, so.
I can tell you that, and I do understand and see your concern, but the minute you do put a number on it and, you know, it comes to light and we have to say, you know, sorry, it's only 39 versus the 40, you know, there's a issue in Title VIII right now that's going to prevent us from, you know, I've had the conversation with Trish with, and we're going to talk to Catherine with, that we're going to have to look at modifying And it's one word. It's in a definition that is going to keep us from enforcing some stuff that's going to make some citizens, you know, a little upset. And it's just in one word, and it ties our hands. So the more specific you are in this, you just have to realize that that's where the complainants and the people who are, you know, affected by this are going to also be tied to that number as well. So that's where we have to step back and say, sorry, it doesn't meet this criteria, and we can't do anything with it right now. So.
And I don't think I agree with you. I don't think it would be smart to put in a specific number, because I think it would be arbitrary at best. I guess and thank you as well for speaking about how important each and every word is, because each word in our ordinances really does matter. But I guess I'm wondering, are there any cases that you guys can think of that you wouldn't be able to move forward with, that you need to, if you didn't have C and D in here? Like, or do they all fall under one of the others? I mean, Ashley gave an example, and I think you mentioned that it would be covered by E. Like, are there cases that you couldn't do what you needed to do without C and D?
Do you want to speak to that, Tricia?
Could potentially.
You're on mute.
I think you're on mute. Sorry.
Can you hear me now?
Barely.
I think there could be potentially some cases that we may not be able to handle. I think D is extremely important. The degree and nature of violations of this title, that gives us the discretion to look at a weed case versus a case where we have a nuisance that is a dangerous structure, or we have excessive amounts of junk, which is causing rodent and animal infestation. Is C something that we could maybe do without? We could do without. I guess I would go back to the system that's in place, and while I can appreciate the concerns presented, to some extent, a lot of our laws are written like this, and you have to trust the system and the prosecutor and the court. In this day and age where transparency is super key, I think courts are doing even a better job at this. When I was before you with the vicious animal ordinance, I think there were some concerns about that, and that ordinance was similar, where you do have to trust the system and trust the prosecutor to make sure that they are a very important part of the check and balance, as well as the code enforcement, as well as the police department team, as well as the judge. This is just a tool that we can look at each of these cases. The number of violations could present itself, and we may not have a lot of the other conditions present yet, or we could have a case that's currently under probation with a lot of tickets, which I would say would apply to one property in particular, but we don't have number 2 triggering, we don't have number 3 triggering, we don't have number 4 triggering, or 5. So yes, it could happen. Is it happening on the majority of our identified properties? No, but it could happen. This property in particular has broken windows right now. So Wendy and Catherine will probably know which property I'm talking about. And that property is absolutely chronic, in my opinion.
And Emily, did you want to jump in on this conversation?
Actually, I had 3 other questions, so I don't know if you're ready for that, and I could drop one of the 3.
Well, hang on just a second. Is there
Sure.
further that you'd like to say, or I guess one way that this can be addressed is when it does come before council, we can take action on it at that time via amendment if we so choose, by vote of council. So that's a possibility, but.
Sure. Or if our attorneys have any recommendations that wouldn't unnecessarily tie the hands of code enforcement and them, but also make it a little bit more specific. I would certainly welcome that in advance of it coming before council as well.
Thank you. Emily, why don't you go ahead?
Thanks. I'll cut my 3 down to 2, as I said, of the proposed ordinance, section 8.42.015A2. I wonder if there might be any reason to expand the language a little bit there so that it applies not just to people who are occupants of the property and or neighboring properties, but would there possibly be a reason to include, I don't know how you would word it, but people passing by on a sidewalk, for example, who might be at risk of whatever the nature of the nuisance is?
Would you like me to respond to that?
Sure.
Okay, sorry. So in general, I'm a little hesitant, and here's why. The common law definition of nuisance is, it generally affects the ability of people to enjoy their property. That's the definition that's been around for ages. And I don't know, I mean, there could be instances where there's a nuisance that's actually, like you described, causing an issue with people who are, passing by the property or something like that. I can't think of one off the top of my head that we've experienced. I'm not sure if Wendy or Tricia can. But that's why that's why it's limited the way it is, because that's just a natural recognition of what the general definition of a nuisance is.
Okay, thanks. I mean, I can imagine a situation theoretically that might be a problem, but maybe that would be handled in another part of the code. My other question has to do with D2. And I think it was just a wording issue in that first sentence. The first appearance for the defendant must be held no sooner than 5 days from the date of service of the summons and complaint, and no later than 20 days, whichever is earlier. The whichever is earlier doesn't seem to fit for me, just from a language point of view.
Yeah, I think you're right. We can fix that.
Okay,
Brian, sorry.
thanks. That's all.
I wanted to jump back to the previous question that Councilwoman Tracy had. Doesn't item 3 address that with adjacent public property with the right-of-way if somebody is walking on the sidewalk?
Yeah, I suppose it could. I think that's more for like public parks, that they're using the public park, but it could apply to the right-of-way, I suppose. I don't know that we've ever had a nuisance that affected people's right-of-way use, to my knowledge.
Thank you. And did we have any other comments?
I just wanted to add that although these are just the basic guidelines, just for you all to note that this is not just the standard procedure for how they handle issues like this, because the very first thing that Wendy and her team do when they go out is they attempt to make contact with the individual and educate them as to what the problem is and try to help them fix the problem. They don't just go out and conduct enforcement action. So I just want to make that clear, that they are efficient in doing that, and they're just not going out and enforcing these guidelines. They go out and they try to be proactive and help the individual solve these problems before it gets to the point of enforcement action.
And just to couple that, I just want to say, Wendy's done an excellent job in her role. She's really able to make connections and talk to people and work things out. She's done a really amazing job since she's come on, so.
Thank you, Wendy.
And just to follow on to that, I know it was mentioned earlier, the code enforcement manual, and we have that mechanism in place to ensure that as new code enforcement officers come on board, or if we have turnover, that those policies and those procedures remain in place to maintain that institutional knowledge and keep that policy and that the strides that we're making today into the future.
Just to walk you through one more step to help you understand, when a case comes in front of code enforcement officers, Wendy and her team do go out, they make contact, they do education. That is generally the first step before we even get to any sort of a notice of violation. So we're generally talking one or a couple of communications. We're talking, maybe 7 to 10, maybe 3 weeks in order to allow the person to come into compliance. Then we move towards issuing a notice of violation. A notice of violation is required under our code. A notice of violation identifies the problems and it identifies specifically what needs to be addressed. The team has done a lot of work on this form. The form is not holding anything back. There's no surprises. If a homeowner or a tenant is uncertain as to what the violation is, then quite frankly, they haven't read the form and they haven't been listening during the discussions. Wendy's team will go out at the deadline for compliance with the notice of violation. They do have the discretion to continue the time period for compliance on the notice of violation. By the time it gets to summons and complaint and comes to me, I would say a lot of these cases, we've gone anywhere from 2 to 6 months of the team working with the property owner. Some cases are quicker, some cases are not. And Wendy's team does a really good job articulating the reasons why some cases have taken a little bit more time with the property owners. The cases that we're talking about here with chronic nuisance, we've gone through this process multiple times. Wendy's team has been out, they've had multiple conversations, they've explained what needs to be fixed, notices of violation have been issued, summons and complaint have been issued. When someone comes into court, and I failed to tell you that, when they come into court, I have the same conversations. I sit down with defendants and we go through every single picture. I explain to them every portion of the code that they've been charged with, and I ask them to complete the following list of corrections. And that meeting may happen 1 or 2 times before we even get in front of the judge. We may have to go to trial. If we go to trial, then the judge once again will explain to them what needs to be completed in order for them to be in compliance. So the purpose of me telling you this, there is a lot of communication, way more communication than I think has ever gone on in Canyon City, way more education. And that's just on a standard case. That's on a weeds case. That's on a junk case. That's on a derelict vehicle case. When we're getting to the chronic cases, this process has been followed. And some of our biggest offenders, we've probably been through this process 5, 6, 7, 8, 9, 10 times. One of the properties in particular, when I started in your beautiful city, I inherited the case in 2018. We've abated that property, I believe, 3 or 4 times. This has been a constant discussion. So that's what we're talking about. We're just talking about the ability to move those cases that we've been spending years on. We've had hundreds of conversations with them and move it through the court system a little bit faster so that we can get some relief for the neighbors and the citizens of Canyon.
Thanks so much for all the hard work that you guys are clearly doing, and especially for all of the hard work that you're doing to really work with individuals and ensure that they're able to resolve the issues that they have without going through this longer process. Thanks for taking the time to explain everything that you are doing as well. It's really appreciated, and it really does help make Canyon a better place to live. If there's a way at all to capture some of that, like this is the process that we are going through before we are considering a case to be a chronic nuisance in the ordinance itself, I think that would certainly go a long way towards making me feel much more comfortable about this. I think it's clear that the process that you have set up, you are doing that, like you are having a lot of communication. You're certainly going out and doing many, many steps, and it's not like this would take somebody unawares that they would be declared a chronic nuisance. But I don't think that we've quite captured that in the ordinance as it's currently drafted. So if it's possible to add in a little bit more of that in the language, I think that would be very welcomed. Thank you.
And is your thought that one place that might be appropriate is in the whereas section, or actually in the wording of the ordinance itself?
I mean, certainly in the whereas, in terms of why we're having this, like why we're actually creating this ordinance and what the purpose of it is and what the intended, what it's intended to actually accomplish. But frankly, I would like to also see it in section 2, where we're defining what a chronic nuisance is. I mean, it certainly seems like you have identified the cases where you have this stumbling block and where you need this additional tool. So if it's possible to, again, I'm not saying put in that it needs to be 40 violations of this title or anything like that, but if it's possible to be a little bit more concrete about how you make the determination that somebody would go through this process, I think that would be great. So I would say in both, in terms of the intent and then the specifics in terms of the process.
Okay. Does anyone have anything else that they'd like to say on this subject? So I think then we're ready to move on to the city charter discussion.
We are, and we have City Attorney Corey Hoffman on the Zoom to walk us through the potential for city charter amendments.
Great. Looks like you're unmuted there, Corey. Take it away.
Absolutely. Good evening. So this is a follow-up to a conversation that I think we had at one of the city council retreats. And I think by way of background, our home rule charter, which is effectively the city's constitution, has some detail in some areas that is somewhat unusual for a home rule charter, where typically you would want your charter to be more of, and I think we talked about this at the retreat, a framework as opposed to putting the actual limitations in the charter. And in other cases, over time, our charter has become inconsistent in some ways with Colorado law. And so the purpose of tonight's discussion is really to look at what we identified as what I would call the low-hanging fruit, in terms of things that are either inconsistent with Colorado law or could be seen as in need of being brought current. And so, I can go through these very quickly, one by one, and just identify, because some certainly are more obvious than others. And I'd frankly use the first one as a very good example of something that is obvious that it should be fixed. And that is that the charter currently conditions which meetings have to be open to the public. And that is inconsistent with the Colorado Open Meetings Law. Any meeting where 3 or more members of the council convene is an open meeting under Colorado law. So that first recommended revision to Article 3, Section 5, we would recommend because it is today inconsistent with Colorado law. The second item, also identified as a priority, I don't know what the origin is of this section, but frankly, municipal government doesn't typically have an executive branch unless you are Denver, Pueblo, or Colorado Springs. In other words, with a strong mayor form of government. If you don't have that, then you don't really have an executive branch of government. So in light of the fact under the city's charter, the mayor is not a strong mayor and doesn't have a vote. Again, we would recommend taking out the reference to executive. The third item is not listed as a priority, but it is presented to you because I think it frankly better reflects the form of government that Canyon now uses, which is a city manager as opposed to a city administrator form of government. And so really this language is intended to clean up much of the language in the charter. And I guess I'd do a little bit of a deep dive and say this. We've talked in a number of different contexts about how no single member of the city council has any authority. The power of the council is as a body. And much of the language in Article 4, Section 1 about it, in the administrative powers in Section 4 suggest that individual council members could, in some cases, have authority. And that, frankly, creates risk to the council. So from a liability perspective, from a risk assessment perspective, having more of the day-to-day operation vested in a city manager is always going to be, in our view, advisable. Is this one a priority? Might this be more controversial? I don't know. Long-term, I'd certainly recommend looking at that provision. But again, this one is less low-hanging fruit and more substantive moving forward. The next one is similar, and it would be an addition to the charter if you were inclined to amend the administrative powers provision to define the city manager and to say that the city manager is responsible for basically the day-to-day operation of the city. And the city manager, and frankly, the city attorney as well, and this is covered in the next section as well, should be, in our view, purely at-will positions. We serve at your pleasure, the city manager, the city administrator, and the city attorney. And the current charter doesn't reflect that. There's actually process associated with having to potentially have the city administrator or the city attorney of your choosing. And I think in today's environment, and frankly, as the law has evolved, if for some reason a new city council takes over or the current city council wants to change direction, your executive team, your appointees should serve at your pleasure. You could be thrilled with their performance one day and then the next day lose confidence. If you lose confidence, you should have the right to have the folks implementing your policies and giving you legal advice that you choose. So we did recommend, again, not as a priority because it's more substantive, looking at your charter and whether or not to kind of clean that up and make it more at your will for those employees. And as to the municipal judge, the law in Colorado is that a municipal judge is subject to reappointment every 2 years, but cannot be removed based on the fact you don't like how the judge is issuing rulings. And so our recommendation would be to have the judge's term be the off year, so that a city council has the ability to evaluate the judge's performance, a new city council for a year, and then decide if that judge is the right judge for the city, as opposed to kind of blindly reappointing the judge, really with a new council not knowing what the performance of the judge has been. And so this would allow the council to appoint the judge at a time when it has been able to get experience and determine if the judge is a good fit for the city. And then if those sections were things that the city council wanted to look at, Article 5, Section 3 of the charter currently provides for removal for cause of your appointees. And again, our recommendation is you should have maximum flexibility for your appointed officers to have the people in place that you want at any given time. And if the judge's removal for cause is deleted, what ends up happening is that state law is a default. And state law is, as I articulated, where you can't remove a judge because you don't like their rulings during the middle of their term. The only basis for removing a judge during their term would be if they were convicted of a felony or had other issues that were beyond just performance issues on the bench. Similarly, and item number 7 in our memo is almost the exact opposite as it relates to all other city employees. In Colorado, excuse me, there is due process and liberty protections afforded to public employees. And Article 5, Section 5 of the charter is frankly inconsistent with the protections afforded to employees of the city, because they actually don't hold their office or employment at the pleasure of the council. They have some limited right in what's known as continued employment. And so this language we would say is a priority because it's inconsistent with current law. Article 7, Section 3 is purchasing limitations. This is probably the best example of language that's in your charter that typically would not be in a home rule charter. Typically, you would say that in a home rule charter that the council is authorized to adopt purchasing policies, but you wouldn't have those purchasing policies in the charter itself. And in fact, they become outdated fairly quickly. And I think if you look at the purchasing policy in the city charter, it is, I would suggest, outdated. And if you have budgeted certain items as part of your annual budget, having a purchasing power limitation that you, as times change, can change flexibly to reflect whether it be inflationary costs or council saying we want certain protections in place for purchasing. We would suggest that's better done by ordinance than in the charter. The next one relates to limitations on the cemetery fund and the park improvement fund. Now, again, we did not identify these as a priority. They are unique to be in a home rule charter. But I think there is also some history there, at least as to the park improvement fund, that the council could want to consider in terms of whether it wants to look at these amendments now or at some point in the future. Item number 10, again, I would suggest is a priority, and that is that the city is spending money publicizing in a newspaper of general circulation a list of warrants, not required by Colorado law, but required by your home rule charter. If the city council desires to have some publication of its warrants, its expenses, there's a whole host of ways to do that. There's various systems that can provide, even on your website, for example, all of the expenses, but the fact that it is required to be published in the newspaper is outdated. And I would ask you kind of rhetorically, how many people still read the legal publications portion of a newspaper? And I think with the open meetings law in Colorado and with other areas under Colorado law, electronic publication is much more the norm than newspaper publication for a lot of things. Item number 11 is how the process for adopting an ordinance. Again, it has to be published in full in a newspaper of general circulation. And my question to you would be, do you think that is the best way to get information out to your constituents? I I would suggest that publication potentially electronically, whether it's on the website. Certainly you can put it in the newspaper by title, but the city, I suspect, is spending a lot of money by publishing in full in a newspaper of general circulation its ordinances. And so you will see that we have suggested a potential process for adopting ordinances that still has 2 readings, but is probably less expensive in terms of publication costs. And then we also added proposed language that again is consistent with Colorado law that authorizes in certain limited circumstances the city council to adopt emergency ordinances which take effect immediately upon adoption. Number 12 relates to public parks, and this has been a source of discussion several times over the past couple of years. I guess I would suggest that if you have a subdivision and someone wants to dedicate park property to the city, Article 14 of the charter would require the city to hold an election to accept that dedication. If that's consistent with what the council wants, then absolutely you shouldn't touch it. But as the city grows and evolves and has opportunities to acquire parks, even by dedication, this could be seen as a significant constraint on the city's authority to do that. Number 13, the last priority item. The state law gives municipal court authority for fines to be $2,650 per offense per day as of, I think it was 3 years ago, and then subsequently adjusted by inflation. The city's limit in the charter is obviously much lower than the state law provision. And again, we would suggest potentially simply saying that the municipal court limitation is as provided by law, and then Canyon City would follow state law on the limitations of its municipal court jurisdiction. Article 15, Section 15, there is reference to airports and landing fields. I'm not aware of airports and landing fields in Canyon City. I don't know the origin of that provision, but we tagged it as something you could consider. And then the last issue relates to the mayor in 2 ways. First of all, the charter currently has the mayor having a 2-year term, while all the remaining council members have 4-year terms. Yet, frankly, as we talked about, it's not a strong mayor form of government. And so one possibility for the council to consider if it thought it appropriate would be to have the mayor have the same term as all the other council members. In other words, 4 years instead of 2. Lastly, related to the mayor, and again, this has come up, so we identified it, it's come up in the past. If council desired to make the mayor a voting member of council, there are ways to do that where you would not have to necessarily add another council member to create an odd number. Some communities have the mayor having a veto power, which is then overridden by a supermajority of council. Again, we throw it out there as a possibility, but those are at least the potential charter amendments we identified. And from the retreat we had, I believe council's direction was to at least consider, at a minimum, some of the low-hanging fruit at the November election. And so if the city council wants to consider these for the November election, now is the time to give us direction in terms of which of those charter amendments you would want to present to the registered electors of the city.
Any comments from council? Dan?
I think right now, I would like to just go over it just a little bit more and just really sit down and study, even though I have looked when we did this. But I'd like to sit before I make a final decision on where we want to send which ones. I'd like to sit down and I don't want to say put it off for very long because I know with elections that's a timely matter. But I'd like to have a little more time just to follow up on this a little bit more, and that's my personal.
Thank you, Emily, and then I'll get to you, Amy.
Hi, I wondered if I made notes on some of the suggestions and some of the different articles, and if we're going to discuss any of these, I would just suggest that we walk through it article by article so that we're not jumping around a lot. I don't know, I think I may have something like 6 or 8 questions or comments to make on different sections. So just wanted to throw that out there.
Thank you. Amy?
Thank you, Mayor Pro Tem. I also have some notes and have some thoughts about a lot of these. I'm also, though, I just want to say I'm a little bit concerned that, and I definitely want to make sure that we get input from the residents of Canyon City on this as part of our evaluative process as to whether or not we do want to move forward with any of these. I was a little bit concerned that our general government meeting just had city charter updates and there was no additional public information, so people really had no idea what we would be talking about tonight. And I find that to be really disconcerting because I don't know about the rest of council, but if I went to the agenda and I saw city charter updates, I wouldn't know enough to know whether or not that's a meeting that I need to give up an evening of my life to attend. And I think that these are really, some of them, you know, it makes sense. Obviously, all city council meetings shall be at all times be open to the public. Like that makes sense. We need to be consistent with Colorado law. But there are a lot of other really significant, you know, proposed changes that I know I personally have a lot of concerns about. And I just want to make sure that we are really involving the residents of Canyon City in this deliberative process. Thanks.
And if I could address process for a minute, the question is whether or not to put these on a ballot. And if you decided you wanted to put them on the ballot for November, because the charter can only be amended by a majority vote of the registered electors of the city of Canyon City. But what Ryan and I certainly have talked about is that while you cannot spend public money advocating for or against any such questions, you absolutely can have factual summaries of the question and can have meetings to explain what the charter amendments are intended to do. Again, without advocating one way or another. So I appreciate your comment, absolutely, but I also want to make sure that it's clear that this would be the first step to a longer engagement process that would culminate in hopefully an informed electorate in November making decisions on whatever charter questions, if any, the city wanted to present.
Well, and I think to Amy's point, that before we go through the bothering to even put something on the ballot, that there's no harm done in having a focus group or 2 focus groups to go over these and just make sure we're in alignment with the public. And I don't want to put anything on the ballot that's going to cause a lot of angst with the community. And let's go for the no-brainers to clean things up and make it as clean as it can be. And there's some that just might, like the mayor going to 4 terms and having a vote. I don't really have a strong opinion about that. I'm okay with it being there's 2 years, and I'm okay not having my vote. Because if I ever do have an opportunity for a vote, I will win that every time. So if the public has a different feeling for that, then so be it.
And I'd just like to add something that we mentioned but didn't highlight here. The charter, you know, I'm not sure do we know when the charter was originally written?
1945, I believe.
1945, and the last amendment was 1981. And so we have a document that's over 40 years since being amended. And as we all know, if we went back to our state constitution 40 years ago, a lot of things would be very different.
I think there were more, 2000, maybe the most recent round of
yeah, I
amendments, but
think-
that's still 22 years.
That particular section was last amended in 1981.
Oh, and 80, so that
Yeah.
was that particular section only.
Correct. There have been more recent amendments, I think in the mid-aughts.
Thank you. Thank you for that. So comments from other city council members on how to do this. I mean, we've heard Amy from you, we've heard from the mayor. Any other city council members have an idea? And we heard Emily's process ideas, which sound sound. Yeah.
You're looking at me, and it's one of those, this is the first time I've had a chance to look at this documentation. Ryan emailed it to me during the meeting. So I would like to have a little more time to look through it, but I do think it is important to get reaction of the general public, because I think we do need, again, a ballot issue. Unfortunately, trends tend to be anymore to, when in doubt, vote no. And I think we need the education of it is very important. And I think just having gone through this as it was written and read by Corey is that I think it's very important. I think there's a lot of good things that could be changed, but I think we need to digest it just a little bit longer and get some, as the mayor has suggested, some focus groups or something that way.
And certainly if we have informational needs, that goes double or treble for the public.
Right.
Yes, Amy. Oh, Andrea. Sorry.
Yes, thank you. I think focus groups are a great idea, but I think we need some way to make sure that every citizen of Canyon City sees just what these mean before we put it on the ballot. And so, and that, I think that would avoid any miscommunications, because most people, even if we had a meeting, a general meeting, and invited the public, we're still not going to get the majority of people who, for whatever reason, cannot be here. So I think we need to do some sort of posting, and not the whole charter, because people aren't going to dive in there and read the whole thing, but just what we're changing and why, and, state that in a way that people can understand, and make sure that, I know a mailing would be very expensive to send to everybody, but maybe we could announce on our meetings and put it in the paper, and that they could come here and pick up the flyers or call if they'd like to have one mailed to them.
So some ideas we've done in the past are like Q&As, so we'll have like question and answer forms. It could even be on a water bill where there's a QR code, or in a website where they could scan it and they go right to the website to access those Q&As. And
Well-
we can publish it in the newspaper in print for all to see.
Yes, actually, but the whole, the online aspect of it, I think we've learned already, John, that many people are not comfortable with that. So there's a large portion of people in this town that a QR code or website is not going to get it for them.
Yeah.
They need to be able to see it, and,
Well, that's where the general publication.
right.
would come in.
Right,
Yeah.
but still, in the paper, not everybody gets the paper, so maybe.
Well, you do all of the things. You do every single one you can
Right,
think of, you do
right.
all of them.
But just
So
so
it
that,
takes
that
care of
everyone
everyone.
has access to a print version of it if they want it.
Right.
And I think one sidestep, maybe the paper is, we could take out an advertisement in the shopper. Everybody gets the shopper. And, at least to promote that it's happening or that this is being considered.
And I think that that may be a good idea, but we probably need to have a little more meat on the bones for that publication. And that's where I think Kathy's comment comes in, and Tim's comment about needing a little more time to digest and see what exactly is being proposed and what's the current language, what's the benefit, and then maybe go from there. And yes, I see Corey, yes, and I also see Emily. Hang on.
Okay.
Go ahead, please, Corey.
One suggestion to at least consider is, that if you truly had, and it could even be 2 or 3 of the really, really basic questions, such as, the making sure that all the meetings are open to the public and eliminating the language about employees serving at the pleasure of the council. And I'm just picking those out as an example. But, one other way to do more substantive charter amendments is to have kind of a citizens advisory group that advises council, that sits down and goes through the charter and makes recommendations. And one way, frankly, to introduce that process is to have some initial questions that say, look, these are clearly problematic in today's environment. And again, I use the open meetings law as probably the best example, but it also gets people thinking about the charter. And then you can have a longer term process to really put some meat on the bones in terms of long-term charter amendments, either city council directly or through an advisory commission or both. And it is pretty common to have that sort of 2-tiered approach where if we know that something just needs to be fixed, here we're fixing this, but we're going to have a long-term process, and we want you to be involved in kind of having a constitutional convention, if you will, to update the charter.
That's a bad word, constitutional convention. I don't like it.
Yeah.
Kathy?
But I was just saying, as far as like advisory board, I don't necessarily want to be in a position where like council is voting to select who's going to be on this advisory board. I think it needs to be, that just feels wrong. It should be open to whoever wants to be there and participate. And so focus group might be more of where, and we can invite people that we know that would be really, intellectually minded and have a really good track record of digesting these things and going through it, but it's also still open to those who wish to be a part of that process too.
And timing wise, we need to know if the city council wants to put any questions on the November ballot fairly quickly.
And so let's talk about that just a second. And we do have several people that want to speak here, and we'll be getting to them. But what for our edification, what are the kind of deadlines that we have to meet to get something on November's ballot? Because I can say that, if there are some what we think are low-hanging fruit that may be relatively easy for people to understand and come to their own conclusion on, maybe we limit the particular ballot amendment to that. Where the more difficult ones that may require a lot more public discussion, maybe we not try to rush this too much. But what are the timelines and timeframes that we're considering here?
In a general sense, we need to give the county notice of intent that we want to participate in the November election next month, so in July. And then the ballot questions essentially have to be finalized and approved by the end of August, because the ballot content has to be ready for basically by the beginning of September. So the end of August is really the deadline.
And who writes the ballot language?
We do, and then it's presented to you for approval.
Thank you.
Ryan,
Okay.
I have a lot of confidence in you being able to put a focus group together.
We have some other people here. Kathy, you want to jump in here, and then I'll get to Emily, and then Amy.
I was just going to say that the state puts out the Blue Book, And I was wondering if we wanted, there's an option there to perhaps do a minor version of that. And it gives pros and cons. And that way, it maintains neutrality, but it gives the people as much. And I don't know if it could be as an insert in the shopper to where maybe we don't have to mail it out, but it would be something that could be distributed by the shopper.
You can
So
do
that's
both.
an
You can do
idea.
both. So any ballot measure goes into that blue book.
Okay.
Okay?
But that's absolutely correct. You could do a factual summary that goes in the shopper. So as long as it is not advocating for or against, the city could do its own version of the blue book as to its constituents, giving the factual summary of the questions.
Thank you. Emily?
Just on that topic, and then I have a couple of quick comments too, or questions. I think with the state blue book, there's a process by which they invite proponents and opponents of the ballot language to submit a certain length statement to be included in the blue book. And so, you know, we could do something like that where we provide the factual information, but also if there's anyone out there in the public who wants to comment either for or against, we could provide that and model it after the blue book that way. One of my quick questions for Corey was just, can we do, I assume we can, but can we do charter ballot issues each year, even and odd years?
Yes.
Yes, okay. And I'll just say right at this point, I'm kind of agreeing with some other comments already that I'm inclined to want a little more time to look at all of this. I've certainly gone through it all and looked at the existing charter language and the suggested changes. If I had to make a decision tonight, I'd say, let's just do the stuff that we know we want to change to conform with state law, and then have a longer process for the other things. Some of them, like the airport issue, I'd be inclined to just leave that alone. I'm not sure what the historical reason was for that, but maybe someday there will be something that relates to that. And so I say, let's not try to have a charter convention. In other words, I don't want to feel obligated that we have to make lots of changes unless there's a need driving those changes or push from the community or whatever. So that's where I am right now. That's all.
And let's see, I got you, Kathy and Amy.
Thank you, Mayor Pro Tem. I agree with what my colleagues have said and really appreciate Councilmember Worthington's suggestion. I think doing a blue book would be a phenomenal way to meet some of what Councilmember Stein had mentioned earlier. One thing that I would propose that we do, though, is after everyone has a little bit more time to digest, I do think it would be wise for us to go through and talk about each one and maybe narrow it down a bit. I don't necessarily know that a majority of us would agree with all of these, so I don't know that we want to put all of this out into the focus group universe. I think it makes sense to try to winnow it down a bit, maybe do have, you know, some of the really just cleaning it up and ensuring that we're in compliance with state law, and then a few of the ones where we're, you know, we think it makes sense and we're supportive, so that we're not trying to do too much, and so that we really are trying to focus and make the best use of our citizens' time.
Well, based on that part of the conversation, if we just want to leave airports there because you just never know what's going to happen, then let's just leave it there. Let's not bother that with a focus group. Based on the conversation today with the newspaper print, apparently we still need to have things in the newspaper. So maybe we need to still leave that alone until it truly is obsolete.
Or at least have the option,
Yeah.
of doing both or whatever, because technically is the shopper a newspaper of general circulation?
I don't believe it would be considered general circulation because it's
Although
a
it
weekly.
technically is the most circulated paper in Fremont County.
And so that's why a little flexibility there maybe.
Because I was talking to the editor, I think Daily Record is only like around 1,600 or something. I mean, it's very small of how many people are actually getting that paper.
Well, and one thing, if you pull it out of the charter, you can always pass an ordinance that says these are the places where we're putting this stuff. And you can designate a publication, you know, like the Shopper, that may not be a newspaper of general circulation.
But I also think that we've heard repeatedly from people who live here that they need greater transparency from us, not less. So I don't think that we should, I agree, we should be posting it everywhere that we possibly can, and I don't think that it sends the right message that like one of our questions for changing the charter would be, let's make information more difficult for people to find. Like, I don't think that that's the message that any of us would want to send, and since we have heard from folks that a lot of people show up on second reading because the entire ordinance is printed in the newspaper. I would just hate for us to get away from doing something that people really do find to be a valuable tool. And I think, you know, publishing just the title of it, oftentimes the title may not really, similar to our agenda this evening, the title may not give you enough information to know whether or not you need to be there. So I just think we need to be more transparent and have things in more places. Thanks.
Okay, did you have another comment, Ryan, or?
Yeah, I was just going to ask Corey, could you talk a little bit about the process? I know Councilman Hamrick asked about the question, but in this case, we're actually talking about questions, correct?
Well, it's up to the council, but yes, it would be putting whatever low-hanging